Great. So before we start, we're gonna have the first legal staff give us a summary of the case, and then you're gonna have 7 minutes to speak about your item. Go ahead.
Thank you. Good evening, Commissioners. This appeal presents an almost identical fact pattern to the petition E-92, which you heard last month. The board should apply the law in the same way it did in that case, which resulted in the exemption of one of the 3 units in a converted triplex, because that unit was substantially comprised of new residential space, whereas the other 2 units were created by remodeling and subdividing existing residential space. 2504 Dana Street was a large single-family home that was operated as a rooming house prior to the landlord's acquisition of the property. In 2012, the landlord applied for a zoning permit to convert the building into a triplex and began renting the units in August of 2013. The conversion created a new unit, Unit C, by raising the roof to create additional residential space in the attic and subdivided the lower levels into Units A and B. In May 11, 2017, staff attorney Matthew Siegel issued an administrative determination that the property is not exempt because the units were created from existing residential space. He cited Berkeley, LLC v. Wiley, and a case interpreting the Costa-Hawkins new construction exemption. Berkeley held that the Certificate of Occupancy that results from the conversion of one type of residential use to another does not receive exemptions from rent control. On appeal, the landlord argues that the board should ignore the Berkeley case and interpret Costa-Hawkins more broadly. The landlord claims that the board has no jurisdiction to interpret the applicability of the new construction exemption, that the legal authority relied upon by the hearing examiner is inapplicable to the facts of this case, and the decision has impermissible retroactive effect. The arguments misconstrue the law and the legal effect of board action. By the way, a lot of this you heard last month, but the appeals are so similar that I'm going to repeat it for purposes of creating a record that you all heard. You all heard the legal staff's recommendation on this. Essentially, Appellant would have you believe that the Rent Board has no authority to ever interpret Costa-Hawkins. This simply can't be so. Remember that Costa-Hawkins as a law has no independent authority other than to provide limitations on the way that jurisdictions are able to implement rent control. It is a law that circumscribes municipalities' abilities to impose controls on rents. Nowhere in the law is there a specific reference to any one city. This is just a set of rules that bind rent control jurisdictions. The board literally must interpret Costa-Hawkins in every single hearing because Costa-Hawkins eliminated broad swaths of the ordinance. First, the board certainly has the authority to interpret the exemptions from the ordinance. That is the most fundamental aspect of determining whether or not the board has the ability to proceed with imposing rent ceilings and adjustments. Second, the legal conclusions in the Berkeley case are not narrowly tailored to apply only to condominiums. The court held that the purpose of Costa-Hawkins exemption for new construction is to encourage the creation of units that enlarge the housing supply. Units C enlarge the housing supply, and units A and B merely reconfigured an existing residential rooming house. Therefore, we believe the hearing examiner should have exempted unit C to achieve the result required by Berkeley, and to be consistent with the prior decision that you all reached last month in petition E-91. Third, appellants introduced the novel approach of, quote, countable integers as the method for evaluating whether a project enlarges the housing supply with zero legal authority. The units in Berkeley and Da Vinci were, quote, units, but courts upheld those cities' determinations that those certificates of occupancy weren't indicative of new housing supply. Appellant would have you ignore Berkeley and Da Vinci on the theory that the facts are distinguishable. However, as we laid out on page 6 of the recommendation, the facts of the cases are actually quite similar. Reliance on the Palmer case by the appellants is misplaced. The legislature acted to supersede Palmer because it was overly strict in interpreting Costa-Hawkins. It has no precedential value. Fourth, appellants argue that the application of Regulation 510 to this property might somehow lead to a different result. This argument is completely without merit. The title of Regulation 510 is Definition of New Construction for Units that Lack a Certificate of Occupancy. And the regulation plainly states that it deals with certain newly constructed rental units for which a certificate of occupancy has not been issued. This property has a certificate of occupancy, so Regulation 510 simply does not apply. Lastly, nothing about the decision applies retroactively. Rent control applies going forward, not back to when the unit was originally converted. Laws change, and the units may be subject to new regulations when they do. The hearing examiner correctly determined that units A and B are not exempt from the Rent Ordinance. However, we believe Unit C was created from uninhabitable space in the attic, and therefore the board should modify the decision to exempt Unit C, consistent with your decision in petition E-92 that you reached last month. Thank you.
Thank you. The appellant will now have first 5 minutes.
Thank you.
No, actually, you have 7 minutes because, so go ahead.
All right. I don't know that I'll need that much time, but thank you anyways. While we do appreciate the acknowledgement that the decision was wrong as to one of the 3 units, we believe it was also wrong as to the others. Microphone is not on here. Okay, we believe it was also wrong as to the others. This case does concern the property at 2504 Dana Street, which was prior to the ownership by the current owner, NCR Properties, categorized by both the Zoning Adjustment Board and the Building and Safety Division as substandard, incapable of being occupied. It was vacant, it was dilapidated, and it was the subject of numerous notices of violation. The owner at that point in time had 2 choices. Could have returned the property to its last legal use as a single-family residence, or it could have attempted to convert it into a multi-unit property. To best serve the interests of the community, the nearby university, and to increase the stock of residential housing supply, the owner elected to attempt to convert it to a multi-unit property. It is worth stopping here to consider what would have happened had the owner elected the alternative. Had the owner restored the property to its last legal use as a single-family residence, it would have been a property entirely exempt from rent limitations. This exemption exists as a matter of that same law that Mr. Brown was just talking about, the Costa-Hawkins Rental Housing Act. It's not questioned or challenged as part of the staff recommendation, that is the law. That was a viable option available to this owner. Had the owner restored the property to use as that single-family residence, it would have reduced the stock of residential housing supply. Records from the past would show that that single-family residence previously contained somewhere between 5 and 10 bedrooms. Instead, as I said, the owner elected to pursue the conversion of the property to a triplex. In opposing that effort, the Rent Board's executive director opined that since the proposed conversion requires the issuance of a new certificate of occupancy, the approval of that application would result in the creation of 3 new units that are exempt from rent stabilization per Berkeley Municipal Code Section 1376050, thereby resulting in the elimination of rental units. Now, Mr. Brown takes the opposite position, but in any event, in pursuing the conversion, the owner understood and reasonably relied on such representations that were made to him by the Rent Board's executive director. Did so at the expense of pursuing the creation of a lawful single-family residence, which would have also been exempt from rent stabilization. Now, when that decision and that election has become irreversible, it is apparently the position of the board's legal staff that the units are not exempt. This position is supposedly based on a literal reading of a case called Berkeley v. Wiley. We don't suggest that you ignore that case. We just say that that case is not applicable to the present case. Berkeley v. Wiley was a case involving a rent-controlled property, distinct from the present one, containing occupied rent-controlled units, also distinct from the present one. The owner, in that case, as a means of trying to escape rent control, applied and was successful in converting those units to condominiums. That owner was not successful, however, in avoiding rent control because the court in Burien noted that a couple things were true. First, the acts of the owner had not added to the residential housing supply. Second, the configuration, its number of units, was the same before and after the conversion. And third, it was effectively nothing more than a paperwork conversion, where the owner filed some paperwork and was not trying to sneakily avoid rent control. So the outcome in that case was as expected. Conversely here, the property owner did advance the goal of adding to the residential housing supply. It took a single-family resident and made 3 new units, not 1 new unit, not Union C, but Unit A, Unit B, and Unit C, to turn a property of questionable and substandard use into one with 19 bedrooms, 9 bathrooms, 2,000 square feet of entirely new space, and a property now capable of housing approximately 35 individuals. This case, as 180 degrees from the case in Burien, serves the goal of adding to the residential housing supply. To the extent that Burien has bearing on the case, it supports the conclusion that the exemption should apply to all of the units. At the law, there are things called maxims of jurisprudence. Maxims of jurisprudence are ways that we try to assist ourselves in applying the law. One of the maxims is if the reason is the same, the rule should be the same. And in this case, we have an instance where Burien is being applied to Dana. And we have different reasons, clearly different circumstances, and yet the rule is the same. That is not how the law is to be interpreted. The staff recommendation is also flawed insofar as it isolates a portion of this property as supposed new construction, while deeming the balance to be pre-existing. The distinction it attempts to draw there is that if residential use existed in part of the space, it is non-exempt and vice versa. This approach is flawed because it leads to an entirely unworkable and entirely gray area of what are and are not exempt units. By way of example, is a unit exempt if the lawful use is commercial, but illegal rental use, residential use is made? There's no clear answer to that, and that would be the result from this rule that's being proposed here. The recommendation points to the fact that the property contains roughly 28% more residential square footage than before. Does 10 feet of additional square footage, is that enough? Is there a threshold amount? None of these rules exist as a matter of Costa-Hawkins, and none of these rules should be implied in through the Rent Board's rules here. Conversely, Costa-Hawkins sets forth a bright line rule where there is a certificate of occupancy that is issued, the resulting units are exempt. Does not require consideration of residential use, non-residential use, percentage increases, or anything like that. It's a simple, easy standard to evaluate. Burien did not alter this rule. In fact, the words prior to residential use, prior to commercial use, none of that stuff exists in Costa-Hawkins. Lastly, the policy behind this decision is a dangerous one. Costa-Hawkins may not be popular insofar as it's viewed as an affront to rent control. But there are and will be other properties, like we heard about a month ago, like Dana Street and like Waring Street. In fact, we had that one a month ago. Berkeley's interpretations of these rules is that conversions of prior single-family residents to duplex, triplex, bigger, newer properties defeats the exempt status. Owners will not pursue these conversions. This will have the opposite effect of what Costa-Hawkins intended, and the opposite effect of what Berkeley should be promoting. The decision should be modified and all 3 units should be determined to be exempt based on the new certificate of occupancy that was issued for all 3 units in 2014. Thank you.
Thank you. Go ahead, Commissioner Jacob.
Thank you, Madam Chair. Thank you for your presentation. I first wanted to be clear on something that I think I've heard you say, asserting that the present owner could have, if he wanted to, created a single-family home. Is that accurate?
Yes, that was the
Okay.
last legal use of the property.
So my question is, in that scenario, how many separate lease agreements would he have envisioned renting to?
Well, typically in a single-family residence that's used as a single-family residence, there's one lease agreement.
However, in this case, the immediately preceding use was actually as a rooming house. So the typical usage that Mr. Friedman described, I won't dispute, but was not the usage either in this property nor the Waring Street property that you saw last month. the landlord was individually contracting with tenants to rent rooms in a very large residential property.
Thank you. And so that gets to the heart of the question I was going to ask next. I direct you to the zoning board, the City of Berkeley Municipal Code definition, and also the Rent Board definition of a rooming house. A building other than a hotel or lodging for 5 or more persons is provided for compensation, whether direct or indirect. What would have been the distinction between the previous use as a rooming house and the present use had the owner gone the single-family home route?
Well, the previous use as a rooming house use was, as far as everyone who's done all the records show, was illegal. It was not a legal use as a rooming house. The property at that point, when this owner acquired the property, was vacant. So had this owner pursued its legal use as a single-family residence, the use that it would have pursued would have been a single lease for the use of the entire property by a number of occupants.
Thank you.
Can I shed a little bit of light on that? Mr. Friedman brings up a good point about the legality of the use. This is one of the areas where the planning code and the rent ordinance have some disharmony. So while it might have been illegal according to the planning code, it was absolutely not illegal according to the rent ordinance. And the commissioners tonight are here to look at rent ordinance issues and not planning code issues.
Commissioner Appellant.
Yeah, I guess I would say I'm not particularly concerned with what could have been, I'm concerned with what is, right? And what we know is that pursuant to the standard we set in the previous case, that if the use had been housing, and it continues to be housing, then rent control applies. And that if there is new space generated that had not been habitable before, that rent control should not apply. So consistent with our previous ruling, I would move to adopt staff recommendation.
And I'll second.
And exempt the 1 unit and continue to keep it, what would the correct language be?
If you just adopt the staff recommendation, it'll incorporate the exemption of Unit C and the coverage of Units A and B.
And then adopt staff recommendation.
And I'll second that, thank you.
Thank you. So, we have a motion and we have a second. All in favor?
We should take a roll call.
Okay, so let's take a roll call.
To adopt the staff recommendation, Commissioner Albert,
Aye.
Chang,
Yes.
Murphy.
Yes.
Pablak.
Yes.
Pablak,
Yes.
Solosky,
Yeah.
Simon-Wiseberg,
Yes.
Soto-Vigil,
Yes.
Traeger,
Yes.
Liberty.
Yes.
Motion carries unanimously.